Yes.
Item number 1.
My Lord, may it please your Lordship. This writ appeal is against judgment and order dated 13/8/2024, passed in WPC 96 of 2022, passed by landed single judge. The judgment and order is at Roman number page 1, my Lord. It started from page 1. The relevant portion is at page 14. My Lord,
Page 14?
for Roman number 14.
Yes.
Yes, my Lord. My Lord, from third line. Therefore, in view of declaration made by the late government servant not having dispute by the respondent number 5 during his lifetime, and in view of the dual pension having been made permissible with effect from 24/9/2012, the petitioner number 1 cannot be denied the family pension as admissible, and likewise, all the petitioner cannot be denied from receiving the CRG as per their respective share recorded in Form 1 of Service Record of the late government servant. Thus, the impugned decision as conveyed via letter dated 18/2/2021, Annexure 22 is hereby set aside. The official respondents are accordingly directed to grant and disburse the family pension of DGRG to the petitioner by doing all the needful within the outer limit of 3 months from the date of receipt of certified copy of this order. My Lord, the order challenge in this case set aside by the landed single justice 18.
What happened to the first wife?
My Lord, the first wife, as per affidavit filed by...
Is she alive?
My Lord, even though I am not sure whether he is still alive or not, however, as per affidavit filed by Assam Rifle, at para 5, Roman number 5, she received pension till 2022.
Page?
Oh. 73.
Page 73, my Lord.
Page 73. No, 73. My Lord, in affidavit in WPC, my Lord, I filed my affidavit filed by...
Madam, all your appeal copy has to receive, have everything.
My Lord, sorry, even though I enclosed the affidavit filed by respondent, however, not enclosing the document.
No.
That is why, if I may permitted to show the record, my Lord, then...
You see, in your writ appeal, you have got to file everything. Everything has to be filed.
Yes. My Lord, mistakenly, we are not enclosing the document, my Lord. If I may permitted to show.
I don't know. Yes, which page?
In my affidavit filed by respondent number 5, Assam Rifle, my Lord.
Page. You know, you don't submit it in a proper form and you don't know the page. It should have been part of your writ appeal. It is not part of your writ appeal. It should be part of the writ appeal. Now she wants us to read this. She doesn't know the page also.
My Lord, in the writ appeal also, I mentioned it about, even though I didn't enclose the document, my Lord.
Madam, do you know the Gauhati High Court rules? Have you read it?
Yes, my
Do you
Lord.
know how to file a writ appeal?
My Lord, it's
There
mistake.
is a certain, you have got
I
to put
apologize, my
everything.
Lord. I apologize. I know very well, but mistakenly not enclosing the document.
You file afresh. We'll see. You file it afresh. Okay.
My Lord, if I may permit it to amend, I just not enclosing the document, my Lord.
You can amend. Right. On the prayer of the learned counsel for the appellant, she is allowed to amend the. No, on the prayer of, you file an application for amendment.
My Lord,
Yes,
if I
my
may,
Lord.
if
Yeah.
paper book is prepared and all the documents will be,
No need, she has to put everything. The appellant has to put everything. That's the paper book. The writ appeal will contain everything.
my Lord.
All the records has to be there. On the Miss Zaru Sampi CGC, pray that she may be allowed to file an application for amending the appeal petition. Praise the Lord, leaves the matter after 2 weeks.
Obliged.
है ना?
I seek your lordship indulgence in mentioning item number 13 of part 2. If this may be taken up after 2 weeks, my lord.
On the prayer of Mr. Victor,
As agreed by both the parties. Mr.
list the matter after 2 weeks.
Deeply obliged.
For admission, item number 1.
May I please your lordship?
My lord, I have submitted list of dates.
Huh?
I have submitted list of dates.
Where is that?
My lord,
Yes.
with due respect, as we know, this is an appeal under Section 37 of the Arbitration Act. It is very limited grounds, my lord. So,
Correct, very limited.
yes, with sincere respect, my lord, this Section 37 does not permit this honorable court to conduct a fresh
Appreciation.
or fixed or to redecide the entire dispute as if it were regular first appeal.
Correct.
So, my lord,
I agree.
yes, the scope of intervention under Section 37.
Any citations in support of your submissions?
Lordship, if I may be given another 1 or 2 days, I'll submit that. This time, I'm very sorry. I did not bring. Lordship,
To buy this chair. What is this? Go down.
the appellant has not so any valid grounds for interference under Section 37. Instead, it is they are only trying to reopen the factual findings regarding the reassessment dated 14/10/2021. So, my lord, their appeal is nothing but liable to dismiss with cause.
So
And-
that is your case. Why do you need some more days? After 1 week, you're going to say the same thing.
If your lordship is inclined to dismiss, yes.
Well, how do you know? I might be inclined. I don't know.
And besides, my lord,
I've got an open mind. I might I might go this way or this way. Depends upon what the submissions are.
and besides, my lord, as I have already submitted, the only dispute is that reassessment.
Only thing tell me something.
My lord,
when we go to that assessment made, which page is it?
yes, but this is not the time for deciding all of that.
Not the time for deciding. When is the time?
Lordship,
If there is a patent illegality, which can be seen right in front of my eyes, then
it is not illegal at all, my lord, because
Not illegal.
that reassessment was not a fresh claim, not a fresh assessment, and not
tell
a
me
new
something.
claim.
What are this thing, broom, punpia?
Yes,
What flower? What does it? What is the word used? Let me see. Page. Where is that?
lordship,
Page-
I have
Assessment,
notification.
my lord, this is at page number 43, 44.
Lordship,
Munpia will be at 44. Serial number 24.
I have
Fruit
notification.
bearing. It says fruit bearing. Munpia bears what fruit?
Lordship, I have Government of Mizoram notification with regard to for calculation of land. Yes,
And what does it say? It says fruit bearing also.
Lordship, may I submit it the same notification?
Yes. No problem. Yes, which portion?
Point number 10, Lordship, in that page. Munpia.
Munpia broom. This
Yes.
is all right.
This
This is all right. This is thick or clump.
yes.
2.5 thick, 4.5 clump. This is
And
all right.
Yeah, and the
But
amount
yours
is
is fruit bearing. Amount 3170. Okay. Amount. Themu.
All the lists in the reassessment were included in that notification, Lordship.
Nimbu, one Nimbu plant, 10,000 rupees. Anyway, there is one aspect.
My lord.
You have not denied, you have said you have no objection.
Yes, they have no objection,
Just a
Lordship.
minute.
They,
When something turns in their favor, sometimes it's good to
my
keep
apology,
quiet.
Lordship.
You have said that you have no objection.
My lord, with that regard, we have made a submission, and we have also.
How can you now turn around? You
My
have
lord,
not objected.
We have also made this submission, and we have also made conversation with the staffs of the arbitrators, saying that we have never made any such submissions. We have,
There's no point having.
My lord,
Supposing
and-
there's a case here in front of me.
my lord.
There's no point you talking to the court master or something like that. How does that help? Where is your request to examine the survey?
My lord, we have annexed many arbitral awards along with the present appeal in the annexures, and in all those cases also that very same statement is reflected,
That-
wherein the representative of NHIDCL have no objection in all the other cases also. And so, my lord, we have also made very clear with the arbitrator that we have the NHIDCL does not make such submissions, and that those recorded phrases, those incorrectly recorded, my lord. That we have.
Then you go before the concerned authority and say that we did not make such submissions.
My lord. And my lord, my learned friend had.
The sanctity
yes.
of an order
My lord.
can be questioned only before that concerned court
My
or
lord.
authority.
My lord.
What you had said, we do not know because we were not there. The only person who can authenticate as to whether you said this or that is before the person who has recorded the said finding. So you have to go to that authority.
My lord. My lord.
Only
However,
thing is that
yes.
he is correct in a way because you have never questioned. You have admitted to the surveyor's report. You have admitted it. Only thing is now I am finding it that you should have questioned it straight away. It appears that you have missed the bus.
And my lord.
Where is before the arbitrator?
Yes.
Wait, just let me see a thing. Before the arbitrator, you see this third assessment was done
Yes.
prior to the matter being taken up by the arbitrator.
My lord.
Where is your prayer before the arbitrator that you should be allowed to examine the surveyor?
My lord, that very assessment, the third assessment, that has not been provided, and that is why my
That
lord.
was not provided
Yes.
during the arbitration period?
No, my lord.
Huh?
No, none.
Not provided.
Yes, and that is why, my lord, we are unable to annex that very copy, even along with this present appeal, because we were not provided with the copy of the third assessment. The only thing that has been brought before the arbitrator is that such and such assessment was made and recorded. Copies were never given to the appellant. And my lord, another aspect is that the surveyor, even though the arbitrator had clearly indicated that the surveyor and the engineer were to be present at the date of hearing. However, those persons were never they never appeared on the hearing.
Date of hearing, their presence, how does it bother you? Unless you have asked for cross-examining them. Yes, he says that this was never brought out during the arbitration proceedings. Is that correct?
Lordship, it appears that it was only a lame excuse because that arbitral award is 15/3/2024, the arbitral award, and they submitted a letter before the arbitrator on 25/2/2025, Lordship, after 1 year. If they truly agree, why waiting that one long last year, Lordship? So it appears.
Yes. How do you say that it was never produced before the arbitrator?
My
How
lord,
do you say that? You cannot make up facts now unless
Yes.
you have put it in the government. Though the fact remains that the survey report is it's
my lord, first
yes.
the first notice of the hearing notice was issued by the arbitrator on 29 August 2023, and thereafter
First hearing on 29.
29 August 2023. On that day, hearing notice was issued by the arbitrator,
Yes. So-
and hearing was scheduled on the 5th of September. 5th September.
Yes. Then
Only 7 days, and in between the first notice of the hearing and the date of hearing, no date was fixed for examination of the documents.
Mr. Counsel, you have got to ask for examination. Where is your prayer for examination?
My lord, that has not been made. However, the only thing that has been reflected is that the representative of NHIDCL has no objection. That is all.
Then, if you have no objection, then why should we allow you to now make a challenge to the same? Let us see the award again. Arbitral award.
The arbitral award starts from page number 38.
38, yes. Come to page 41.
Yes.
Para Roman 3.
Yes.
Please read.
Consequently, a complaint was submitted by the applicant to the then Kala on the aforesaid
Now,
matter.
who is the applicant? The applicant is the appellant here?
No, my lord, the applicant is K. Lian Lira.
K. Lian Lira. So, K. Lian Lira, K. Lian Lira is you.
Yes.
Huh. He would like to solicit by the applicant.
And if I may, my lord, if your lordship will kindly come at page number 43, regarding the assessment of corpse, 43.
Yes.
My lord, there is no mention that the assessment, copy of the assessment was examined by the arbitrator at the time of hearing. The only thing that has been mentioned is that Kala Khozol submitted his action report, his action taken report on interim order dated so and so, regarding damage due to construction of NH06 within the land of Sri K. Lian Lira as below.
Yes, madam, where is the thing? Where is the survey
That has already
report?
been submitted, yes, Lordship.
Huh?
The 3rd September 2021 verification, that was already submitted before your Lordship in the previous hearing.
It was
Yes, Lordship, the 3rd September 2021.
3rd September. No. I'm not on that. The surveyor's report made in October 2021.
That, Your Lordship, I have not been given a copy. I have not.
That, you see, I want to see the original.
Yes, Your Lordship.
Who was part of the survey team?
My lord, the only thing mentioned by the applicant, the respondent number 1 in his application is one Mr. Ardia.
Huh?
One Mr. Ardia, surveyor. That is the only
He's
thing
the
mentioned.
surveyor.
Yes. Only one mentioned. It's not given his full name also.
Lordship, that
One Mr.
assessment
Ardia,
was
that is all.
actually the NHIGCL representative had well known. They already submitted that we do not have any objection with regard to that reassessment. They had very clear knowledge, Lordship, so it is not the issue no more here. And besides, Lordship, as I have already mentioned, this is an Section 37 appeal.
Maybe.
The
You show me.
appellant always try to...
Yeah, but any patent illegality will amount to coming within the provisions of public policy as provided in Section 34.
My lord, there is a judgment, intervention of the court, my lord.
Yes, Ms. Lalun Louis, you were asked to produce the original award. You have produced the original award.
Yes, Your Lordship, the
That is
3rd
you have
September
produced.
2021.
You see, the problem is that it was after the award had been made that this third reassessment has been made. So, it is something which is not part of the award at all, the third assessment.
Yes, Lordship. Lordship, actually that the reassessment is, as I have already submitted many times, it is not a new development. That the assessment was conducted only in the reason that when first assessment was conducted on 16/3/2021.
You see, I would have accepted all the thing. Only thing I need some more proof because your surveyor is, he's very kind to you. Huh?
That is the actual damage which I suffer, Lordship.
How big is your land?
My lane is at page number 33.
You are getting around 55 lakhs for your Nimbu and your Munpia and Bongcho. He's quite, I don't know, quite liberal. Sorting, by being, terret, dragon fruit, per tree, dragon fruit per tree, 10,000 rupees per tree. Have you seen a dragon fruit tree? I have never seen a dragon fruit tree. I have seen a dragon fruit plant. And today also I plucked some dragon fruit. And I know how big a plant it is. 10,000 rupees per plant.
Lordship, actually that dragon
A
fruit
big giant dragon fruit plant.
they counted as a tree instead of standing stock, Lordship, maybe like that.
Maybe.
Yes.
I do not know. I am reading as it is. I cannot go beyond that.
And beside that, Lordship, that bongso, I think it is a hybrid Napier grass. It is a special type of grass grown by farmer as cattle feed. So, my Lord, it is also a commercial crop because
Okay.
the harvested grass is sold in the market.
Oh, really? Phulroa, 3,000 per Phulroa. Nimbu, 10,000 rupees per plant. All the things growing in Mizoram are there in their garden. Everything is there. Okay, let me see.
Lordship, with sincere respect, may I make only one last submission?
Yes.
If the submission I'm going to make goes beyond my limits, I sincerely beg your Lordship pardon. However, I think it is very necessary because the applicant is a government-owned company which received thousands of crores of rupees from the Ministry of Road Transport and Highways. In my opinion, Lordship, the longer the appellant keeps the money without paying the compensation, the more interest it may
No,
earn from
you are
the bank.
entitled to money, but not unjust enrichment.
But
You are
Lordship,
entitled to whatever is due to you, as per law.
the
And
appellant,
tell me, Mr. Counsel, this survey's report is a bit too much. If it was slightly, I mean, we are giving you money for bong cho. Huh? Bong cho is everywhere, all over you. You go along the side of the road from here to react to you'll need 20 trucks to collect. You'll have enough to collect.
Lordship is,
And if it was so valuable, I mean, there will not be any bong cho on the side of the road.
but Lordship, the appellant does not.
And
did
your
not
bong
object-
cho is fruit bearing. It is written here, fruit bearing. Now, what fruit does bong cho provide? I don't know. And your aidu is also fruit bearing. Your sothing is also fruit bearing.
Lordship, it was already mentioned in the notification which I have already provided. All those were included in that notification.
Out here, it does not say about fruit bearing. It does not talk about fruit bearing. It just says munpia, broom, that's all. It just says the cost, the price. It does not talk about fruit bearing or non-fruit bearing.
Yes.
And the broom, 225. Okay. Let me see. Now let me see. Is bong cho here?
Bong cho is not specifically mentioned in
Not
that
mentioned.
notification. Yes.
Okay, bong cho is not mentioned. Then dragon fruit is mentioned.
Yes.
Dragon fruit. Okay, 10,000 is good. Fruit bearing. This is a bit too much. Where is this? Next time the government is going to acquire some land, if they ever acquire my land, I'm going to plant a lot of dragon fruits. 10,000 fruit berries. So everyone should plant dragon fruit. And today I bought 2 kgs of dragon fruit for 150. And in a dragon fruit plant, how many dragon fruits will you get? Difficult. The problem is you have also not objected. But the problem is there's another problem. The arbitrator has not taken any evidence.
Lordship, with the
Has the arbitrator taken the evidence of this surveyor?
Lordship, Section 19 of the Arbitration Act.
Let us see. Section 19.
Yes. Of the Arbitration Act.
Yes.
Clearly provided this arbitration proceeding is not bound by CPC and
That
the,
is there. That
the
is all
Evidence
right.
Act.
Correct. That is all right. That is
And-
correct.
And the arbitrator has also power to appreciate what evidence to be relied or not in that Section 19 itself, Lordship. Section 19, subsection 4.
No, that's all right. No, that's all right. It can make its own rules, or the procedure can be as consented by the parties. That is the problem. You have not denied the thing also. You have not objected.
May, Lordship, as I have already mentioned, this is a Section 37 appeal. It is very limited, so I'll not go deep into that again. But
what about public policy?
Lordship,
If there is a patent illegality, will it come under the provision of public policy by
Lordship.
which award can be set aside under Section 34?
Lordship, actually most of the crops in that assessment are mentioned in the notification which I
Maybe, but
provided.
then yours is the horticulture garden of the world. I mean, everything is there in the garden. And that is also a house site.
The appellant also clearly submitted they had no objection with regard to that assessment.
That is the only thing.
They are giving an opportunity of being heard
That
also.
is one thing that is troubling me. You have not objected, Mr. Counsel.
My Lord, if your Lordship could kindly come at page
Look,
number 14, para 8.
Yes, para 2 of
Para 8, my Lord. Page number 14.
14.
1-4, my Lord.
Yes. Yes.
My Lord, we have stated that on receipt of the order, the instant appellant immediately had sent a letter to the arbitrator saying that these submissions were never made and that
Where? Please read it.
page number 14, 1-4, para 8.
Please read.
At this juncture, on receipt of copy order dated so and so, this office immediately intimated the learned arbitrator for NH06 by letter dated so and so, requesting that the submission of NHIDCL may also be taken into consideration in every arbitration hearing, and the statement NHIDCL does not have any objection may not be included in future cases. NHIDCL does not have any objection may not be included in future cases.
Okay. So he does it by himself.
My Lord.
What is this court order dated 2/12/23? This is what? This is with regard to what?
With regard to their application under Section 34 before additional court at Champai. Lordship,
My Lord, this is
with
what
regard to that, may I have one submission?
the impugn order, my Lord.
You come to Let us see the arbitral award once more
My lord.
at para 5. Kala has no objection to the grievance of the authorized representative of the applicant. He said that Sri K. Lira's land has been assessed on it. He has given compensation. This is Kala's thing.
My lord. And in the last line of that same paragraph, there's a
So there is, you see,
yes.
a representative of NHIDS also not object the complaint. So there is no objection to the complaint.
Yes.
But there is no admission of the assessment.
My lord.
It says has no objection to the complaint.
Lordship, may I take you into page number 47? Marcus para 9.
Yes.
Yes. May I read up, Lordship? The matter and report of Kala Kozol is examined carefully. The only benefit that entitled by the applicant is the asset value, such as value of crops damage and property damage as per assessment on 14/10/2021. And Kala fulfilled the provision contained so and so. And the important line is, Lordship, representative and engineer concerned in respect of NHIDCL has no objection while this arbitration case was heard. So, Lordship, when hearing was conducted, the appellant himself clearly they are present. They have an opportunity for saying whatever they like, but that time they
Yes.
clearly submitted that they.
Page 47, para 9.
If I may take your lordship again at para 7 of the arbitral award.
Yes.
It says that nowhere it says that the survey report was present to be examined. It only says that the Kala
But you,
was submitted. Yes.
it says here,
My lord.
para 7. Para 7
lord.
says Kala submitted his action taken report
And
on the interim
Yes.
order dated by regarding damage, so which within the as below. So this is the report.
and my lord,
It has given. This is the report.
my lord, and again what my learned friend had referred to at para number 9. What has been examined carefully is only the report of Kala. Only report, not
Correct. But the
not
report,
the assessment.
but the
No, the
report,
report is the
assessment.
assessment, Lordship.
but the report contains this para 7. Para 7 is the report of Kala, and the report of Kala contains the survey report. Look, I am not very much finding his the survey report to be very accurate. I don't know if it's that accurate, but the fact remains that you have not objected to it.
And,
It was there in the Kala's report. You have not objected to it.
my lord, what is very clear is that by the time the assessment has been made, road already was constructed, and there was no
Road was
standing-
constructed
Yes.
when?
There was no standing crops to be seen at.
How
at
do
the
we
site,
know
my lord.
that? Those factual disputes we cannot go
My
into.
lord, my lord.
Okay. Let's see.
My lord.
Hearing concluded, judgment reserved.
I would oblige.
Obliged.
But you in a few months' time when we meet again, you please tell me what fruit does the munpia bear?
Obliged, Lordship.
Item number 2.
My lord, in this matter, yesterday we have submitted adjournment request
Okay. Why?
with the consent of the other
Okay.
party.
On the prayer of the parties, list the matter after 3 weeks.
Yes, my lord. Obliged.
Item number 3.
No affidavit.
My lord, will be filing in a week's time.
Mr. Lal Vensang, counsel for the respondent number
Uh,
4, and Mr. Appearing for the counsel for the respondent number 4, and Ms. Zarim Sankui CGC
I'm for respondent number 1.
for respondent number 1 submit that they will be filing their affidavits within 4 weeks. List the matter after 4 weeks.
Lordship, if a specific date may be given.
Give a date. Give the date in the earlier one also.
13th of August. 13th of August.
13th of August.
Oblige, my lord.
4 weeks, 13th of August?
A week's time.
A week is enough.
I hope so. We have already got our
Nobody hopes
instruction.
so. There's no point listing the matter. You be clear. We'll give you time. You want 2 years, we'll give you 2 years. But you file it within the time period given. How much time do you want?
1 week.
Are you sure?
I'm sure.
Within a week. No, but she needs time, no?
We may not be
Required. Okay. Within 2 weeks. Give 2 weeks. This is the matter.
18th of August.
Oblige. Oblige, your lordship.
Which August? 18.
Item number 4.
Lordship, if I may be granted a week's time to file a rejoinder affidavit against...
You have been granted a week's time since April.
Yes, my lord, we have to seek some more information from the client, my lord.
Or you have got a bad case. Okay, the counsel for the petitioners are given one last chance to file their affidavit, rejoinder affidavit. List the matter on. Give a date after 3 weeks.
25th of August.
Oblige, my lord.
Item number 5.
Lordship, as per the office note dated 29/7, ID card has not returned from respondent number 3 and 4.
Okay, right. As per office note, AD card has not returned from respondents number 3 and 4. First. So what is to be done? Mr. Johnny L. Tocham appeals for
Respondent number 1 and 2, Lordship.
special PP appeals for respondent number 1 and 2. Why not finalizing the matter?
Also, they are filing because of that final complaint sheet was not filed till today.
Yes, I
That
know.
is the
That's
reason.
what I'm saying. Why have you not filed? 4 years have
Also,
passed.
I have sent intimation letter to the department, so I have not received yet. So I may be given some more chance.
Right. The issue pertains to the seizure of cigarettes and poppy seeds. Full stop. Despite, 4 years back, more than 4 years back. However, till date, the respondents have not filed their final report, have not submitted their final report. The special PP shall obtain instructions as to why, as to whether the respondents are going to file their final report and the date by which they will be filing the same. List the matter on give a date.
After 2 weeks, Lordship.
20th of August.
Oblige, your lordship.
Item number 6.
My lord, in the last court date, my learned friend had submitted that the properties have been
Mutated in the name of the...
yes, the youngest grandson. So if that is the case, the applicant is no longer aggrieved as it goes to the patriarchal line of their family.
Okay,
So,
very good.
if I may be permitted to withdraw the application, and the reasons for my withdrawal may be reflected in the
Reflected.
order, my lord.
Okay, give me that thing. Okay. All right, Mr. C. Zoram Chana, the learned...
Not C, my lord.
Mr. Zoram Chana, the learned counsel for the applicant submits that as the counsel for the respondent has submitted that the property in question has now been mutated in the name of the daughter of the respondent,
No,
son of the respondent,
Youngest son.
youngest.
youngest son of the respondent. He does not have any, he does not wish to press, the applicant does not wish to press the application any longer, as the property has been passed down to the proper, proper.
To the patriarchal line of their family.
No. Through the patriarchal line of the family. To the patriarchal line of the family. He accordingly prays that he may be able to withdraw the application with liberty, not with liberty. He will have to withdraw the application. Full stop. The prayer of the applicant's counsel is allowed. The application is dismissed as withdrawn. Good decision.
Yes, my lord. The main reason is that they don't want the ancestral property to go to the daughter-in-law.
Deeply obliged.
Obliged, my lord.
Item number 7.
My lord, office notes indicates that service upon respondent number 2 has not been completed. And service upon respondent number 2, the postal consignment could not be tracked because it was sent a little bit way back.
You are appealing for whom, madam?
Respondent 1, my lord, the claimant.
Have you filed your...
We have filed our objection, my lord.
Who is number 2?
My lord, number 2 is the owner of the vehicle. And my lord, he is a necessary party because we have disputed the validity of the insurance
Okay,
policy.
right. Miss
Violet Thamwani.
appears for the respondent number 1 and submits that written objection has been filed. Full stop. In respect of the notice that has been sent to the respondent number 2, bracket owner of the vehicle, comma. Office note indicates that postal consignment tracking could not be done as notice was sent way back on 23/7/2025. The applicant shall accordingly take fresh steps
My lord.
for service of notice upon the respondent number 2 within 2 days.
My lord.
3 days, within 3 days, list the matter on give a date after 4 weeks.
8 September.
I'm obliged.
Item number 8.
May it please your lordship, the copies of the written objection are here with me. I'm already serving to the...
You'll be filing it when?
Yes, your lordship. I'll be filing it by Monday.
By Monday.
Yes, your lordship.
Okay, Miss Lalnunri, learned GA submits that written objection will be filed by 3rd,
Yes, your
3/8/2026. List this matter on 4/8/2026.
Your lordship, this is an analogous case. It may be listed collectively on the 4th for
List the matter
hearing.
on 4th of?
4th of August, your lordship.
List the matter on, that's what I said, 4th of August.
Yes, your lordship.
That's what I said, 4th of August. List the matter on 4th of August.
Much obliged, your lordship.
Item number 9.
9 is the same.
9 also.
9
Yes,
also
your lordship.
same.
Yes, your lordship. That is the same.
Data. Number 9 also same order.
Item number 10.
I think this has to go before the
My lord.
bench of Justice Nelson.
My lord.
Right. This review petition, the review sought for is in respect of a judgment passed by Honorable Justice Nelson Silo. Honorable Mr. Justice Nelson Silo. Accordingly, registry to list this matter before the appropriate bench. Okay. So, anyway, I think that's finished? Okay. Yes.
Your Lordship, may I make a mention?
Yes.
Hearing list item 17.
Ah.
If it may come next week.
Okay, and the prayer made by the counsel for the?
Here, where the petitioners here.
Petition, list the matter in the next week. Any date? No, next week.
Next week.
Okay. Item 11, no one is there. Anyone is ready for hearing? No one is ready. Huh? Leave the matter. As no one appears for the party, leave the matter after 2 weeks.
Oblige, Your Lordship.
So that's all? Okay.